Thank you all for being on the call. Really excited to have our speaker today, Archis Parasharami from Mayer Brown in Washington, D.C. Archis is a litigation partner, co-chair of the firm's consumer litigation and class actions practice, and also a member of the firm's Supreme Court and appellate practice. He defends businesses in class action litigation in federal and state courts around the country, and one of the nation's leading lawyers on arbitration. Just as an indication of how long and how deeply he's been involved in this issue, Archis was one of the lawyers who was involved in litigating and winning the AT&T Mobility Concepcion case, where the Supreme Court held that the Federal Arbitration Act preempts state rules that do not enforce arbitration agreements just because they would not permit class actions. And following that all the way through to last week, where he was involved in winning the Kindred Nursing Centers case that is the sort of the reason for our call today. I should also note that Archis has been a great friend of the New Jersey Civil Justice Institute in the past. He drafted the cert petition that we filed along with the U.S. Chamber seeking Supreme Court review of the New Jersey Supreme Court decision in the Adelese U.S. Legal Services case. Adelese was the sort of the, as most people on the call probably know, was the case that was really the sort of the start of New Jersey's most recent foray into anti-arbitration case law. That was the case where the New Jersey Supreme Court held that to be enforceable, arbitration provisions, you can't just agree to arbitration. They also have to explain what it means when you, how that is different from proceeding in a court of law, in a sense, sort of when you agree to arbitration, to arbitrate a dispute, what are you agreeing to not do? And we've also seen a number of bills introduced in the legislature along those sort of same lines of just holding arbitration agreements to a higher standard. Kindred Nursing obviously puts those efforts into new perspective, and to explain all of that, really who better than Archis Parasharami. So we really appreciate him taking the time to discuss all this with us. And Archis, I think with that, I will turn this over to you.
Well, Alita, thank you so much for the kind introduction, which I really appreciate. As you talk through the history of this, it made me feel like I've been at this for a long time because, you know, as you mentioned, I was involved in the Concepcion case, which was decided in 2011, which was a nice win, but I need to admit that followed 7 years of my career of losing cases left and right, mainly in California, but also in New Jersey, when in attempting to defend class actions, courts in those states, as well as others, though actually a distinct minority of states, held that class waivers and arbitration provisions were unenforceable as a matter of either state unconscionability law or state public policy. So I had to develop a bit of a thick skin for the first several years of my career, and then we were gratified to see what happened in Concepcion. And that's a good place to start because I think it was probably the most significant case on arbitration agreements in a long time in the Supreme Court. And in the 6 years since then, I think what we've seen is a consistent protection of arbitration by the U.S. Supreme Court, looking at a pattern of, unfortunately, in many cases, defiance by state courts that retain the hostility to arbitration that the Federal Arbitration Act was enacted to prevent. I think it's not disputed by anybody that when Congress passed the Federal Arbitration Act in 1925, I guess over 90 years ago, Congress was reacting to the fact that courts were unwilling to enforce arbitration agreements because they were jealous, in a sense, not in a human emotion sense maybe, but certainly in a power sense, jealous of handing their prerogatives over to neutral decision makers who weren't judges, and so that's why Congress passed the law, and the arbitration's had over time an increased and important role in dispute resolution. But what is interesting is in the 6 years since Concepcion, there has been what I would characterize as a resurgence of some of this hostility to arbitration, especially among certain state courts. And as Alita said, the state courts of New Jersey have been in the forefront of that hostility. Now, why is kindred important? I'm going to try and talk a little bit about some of the case law leading up to it, and then talk about kindred, and then see where New Jersey state court decisions fit in. But since Concepcion, the Supreme Court has, in at least five published opinions, reversed the decisions of state courts that have been hostile to arbitration, and in particular hostile to the U.S. Supreme Court's precedents interpreting the Federal Arbitration Act. So there was the KPMG versus Kochi case coming out of Florida, the Nitrolift case coming out of Oklahoma, the Marmot case, another healthcare case that I was involved with, coming out of the West Virginia Supreme Court, where that court had held that arbitration agreements that required arbitration of personal injury and wrongful death claims in the context of a nursing home case were essentially categorically unenforceable. And in the process of doing that, the state court's opinion described the U.S. Supreme Court's precedents as tendentious. So I have to say that was pretty useful fodder for our cert petition urging summary reversal of the decision, and the Supreme Court obliged in that context. But despite these summary reversals, which take place without full oral argument, just briefing on the petition, it seemed like a number of state courts had not gotten the message. So in the last few years, we've seen two cases following full briefing and oral arguments: the DirecTV case, DirecTV versus Inversia, involving a decision by the California Court of Appeal, and then just recently the Kindred Nursing Centers case. And what I think is pretty interesting in both cases is that despite the fact that Concepcion and some of the other arbitration cases have divided the Supreme Court closely, including in some cases by 5-4 votes, DirecTV was a 6-3 decision reached before Justice Scalia's passing, and then Kindred is a 7-1 decision. DirecTV was written by Justice Breyer, and Kindred was written by Justice Kagan, and both Justices Breyer and Kagan were in the majorities in DirecTV and Kindred, even though they had vigorously dissented in Concepcion, and Justice Kagan had dissented in a parallel case, the American Express versus Italian Colors case. So did they change their minds about arbitration and class actions, or the propriety of the use of arbitration agreements? I don't think that they did. I think they probably believe what they thought in Concepcion and American Express, but I think that they have this parallel concern about state court defiance of the FAA and the Supreme Court's precedents. And, if you think about jurisprudence more broadly than just arbitration, which I try to do sometimes, it seems to me that if the Supremacy Clause means anything, it means that the U.S. Supreme Court and its interpretations of federal law have to be respected, and a failure to respect those decisions is essentially throwing a real wrench into our federal system and the system of judicial review of state court decisions. And in the DirecTV case, for example, Justice Breyer remarked about what it would be like if we were thinking about civil rights type cases in the 60s, just as an example. And Justice Breyer at the Kindred oral argument asked very pointed questions, suggesting that he had a concern that the Kentucky Supreme Court was basically defying the Federal Arbitration Act in a pretty transparent way. So let's talk about Kindred then, which is the most recent case, having given that background. So Kindred involved a situation where the respondents, we represented, and I should say that I'm not speaking for my client, I'm speaking for myself, but my colleagues and I represented Kindred Nursing Centers in this case before the Supreme Court, where they operate nursing homes, and residents of nursing homes quite typically and unfortunately are unable to admit themselves. So usually a family member handles the admission. And in the context of doing so, the family member typically has a power of attorney that gives them authority to handle the affairs of their relative. Well, that's what happened here. There were two sets of respondents, Wellner and Clark, and their relatives were nursing home residents who had passed away in the nursing home. And so the holders of the powers of attorney had admitted their relatives and had also agreed to arbitration on behalf of the deceased residents. They signed particular powers of attorney, and I think for purposes of this call, I'm not going to get into the details of the powers of attorney. What I would say is that one of the powers of attorney was exceptionally broad in its coverage, and as you'll see from the Kindred opinion, another one was arguably less broad. We thought it still had extraordinarily broad language, but not as broad. And so what happened was, in the Kentucky Supreme Court, the Kentucky Supreme Court said, we have these two powers of attorney. One, we interpret the language not to cover the right to enter into arbitration agreements at all. The second one, we interpret that we say, well, any reading would say that this is covered, but our problem is, and I'm paraphrasing here, obviously, but our problem is that the power of attorney does not specifically and expressly call out that it is transferring the power to enter into arbitration agreements. And here's where I think the hostility to arbitration comes in. And Justice Kagan explained in her opinion that even though, and here is the phrase that I think is pretty telling, that for one of the powers of attorney, the Kentucky Supreme Court acknowledged that given this extremely broad universal delegation of authority, it would be impossible to say that entering into an arbitration agreement was not covered. That would ordinarily be the beginning and the end of the contract law analysis. But the Kentucky Supreme Court, as Justice Kagan explained, went on to say that that arbitration essentially is different, that the Kentucky Constitution protected the rights of access to the courts and trial by jury. The Kentucky Supreme Court said that the right to a trial by jury is the sole right that the Kentucky Constitution declares sacred and inviolate. And so for that reason, any waiver of a right to trial by jury, which is essentially the core feature of arbitration, had to be expressly provided for in the arbitration agreement. And so the Kentucky Supreme Court essentially adopted what Justice Kagan described as a clear statement rule that demands specific mention of or specific authorization to enter into arbitration agreements. And so Kindred is worth reading because Justice Kagan, who is a wonderful writer, really, I think, calls out this court for paying lip service to the idea that the Federal Arbitration Act's principles were being respected, but in practice not really doing so. So just for some background on the Federal Arbitration Act, at its core, it's a statute that demands the enforcement of arbitration agreements. It contains a savings clause that permits exceptions to that rule, but the exceptions have to be even-handed. You can refuse to enforce an arbitration agreement when there is a contract law doctrine that applies to all contracts. It cannot be arbitration specific. And so in Kindred, Justice Kagan said that it's uncontroversial that the Federal Arbitration Act prohibits a law prohibiting outright the arbitration of a particular kind of claim. That was a kind of issue that was handled in the Marmot case that I described, where nursing home agreements, arbitration agreements, were just viewed as categorically unenforceable by the West Virginia courts. But then Justice Kagan went on to say that the Federal Arbitration Act also displaces any rule that covertly accomplishes the same objective by disfavoring contracts that, oh so coincidentally, have the defining features of arbitration agreements, And then she talked about Concepcion, where the court had hypothesized a law that said, that any contract that disallowed an ultimate disposition of a dispute by a jury would violate the Federal Arbitration Act because it would rely on the uniqueness of an agreement to arbitrate as its basis. And that's worth talking about a little bit. I think in Concepcion, the argument that the plaintiffs made was that that the rule in California that class action waivers were unenforceable was one that applied even-handedly to arbitration and litigation. And so, as a result, the plaintiffs argued that that meant that this was a neutral rule. And that's where, in Concepcion, the Supreme Court said, well, let's think about the example of the right to access the courts into trial by jury. The right to trial by jury is a central feature of arbitration, but it's true that there are state rules that say that jury trial waivers and contracts are generally unenforceable. But the problem is that any rule that essentially, in effect, targets arbitration by attacking a central feature of arbitration, even if not by name, is in effect singling out arbitration for suspect status. And that's what had happened here, that the Kentucky Supreme Court had adopted a clear statement rule that, in Justice Kagan's words, fails to put arbitration agreements on an equal plane with other contracts. There was a ton of stuff that was pretty helpful to our cert petition and ultimately on the merits in the Kentucky Supreme Court's decision that talked about how critical, important, sacred was, the phrase that I think really captured Justice Kagan, the right to trial by jury was. And so when the Kentucky Supreme Court said that any waiver of trial by jury has to be expressed in it was just like saying that any waiver of or any agreement to allow the holder of the power of attorney to enter into arbitration agreements had to be expressed. And that was, in Justice Kagan's words, too tailor-made to arbitration agreements, subjecting them by virtue of their defining trait, i.e. the waiver of jury trials, to uncommon barriers. And that kind of tailor-made targeting of arbitration does not, in her words, survive the FAA's edict against singling out those contracts for disfavored treatment. I think I'm going to stop there in walking through Kindred. And the reason, I'd be happy to answer questions or talk about it further. The opinion goes on to essentially reiterate these themes, that, that you cannot identify central characteristics of arbitration, try and dress them up in the garb of non-discriminatory general contract rules and get away with it. And so, actually, maybe I'll just mention one other point that I think is pretty important, which is that I think the plaintiffs' lawyers understood that that once the court granted cert, that they were going to face some difficulty in arguing that this rule was non-discriminatory. So they took one other interesting tack, which was to say that when it came to powers of attorney, that the rule that was being adopted by the Kentucky Supreme Court was not a rule about the enforceability of contracts, and they noted that Section 2 of the FAA talks about the validity, the irrevocability, and enforceability of arbitration agreements. And they said, well, this is not a rule about enforcement. This is a rule about contract formation, and the FAA has no role to play. And Justice Kagan, it's an issue that has been floated in previous cases, and I think Justice Kagan has never really, I should say the Supreme Court has never really adopted it, but nonetheless, I think had not come out clearly and said the FAA's non-discrimination principle applies equally to contract formation. So here the court did. Justice Kagan said that adopting the respondent's view, the plaintiff's view of whether the FAA applies to contract formation would make it trivially easy for states to undermine the Act, indeed to wholly defeat it. If respondents were right, if the plaintiffs were right, the states could just as easily declare every person incompetent to sign arbitration agreements. That rule, too, would address only contract formation, and then the FAA would essentially mean nothing at all. She said its provisions rendered helpless to prevent even the most blatant discrimination against arbitration. In the end, the court seemed to find the overall question of whether the clear statement rule adopted by the Kentucky Supreme Court was preempted. It easily found that that rule was preempted, and then it left for remand the question of whether, with respect to one of the two powers of attorney with a bit more narrow language, whether the impermissible taint of the preempted clear statement rule had impacted the Kentucky Supreme Court's interpretation of that language. So that will go back on remand. But as to the first more broad power of attorney, the Kentucky Supreme Court has already admitted that, but for its unique arbitration-specific interpretation of the power of attorney, that it would have said that arbitration was covered. So on that issue, the Supreme Court simply reversed. There is a dissent in the case by Justice Thomas, and it's a very short dissent, and what it basically says is that Justice Thomas does not believe that the Federal Arbitration Act applies at all in state court proceedings. And he has maintained that position consistently since 1995, I think, in the Allied Bruce case, and it simply has just never changed his mind on that question and votes consistently that way. The precedent, Southland Corp versus Keating from 1984, is the case that established that the FAA does in fact apply in state court proceedings. At the time, it was a narrow decision. I think it might have been 5-4. I can't remember, but you know, there were a number of dissenters. In any event, the Supreme Court has largely appeared. You know, here are 7 of the 8 justices. The new Justice Gorsuch didn't participate, but you know, have clearly either at least implicitly signed on to the idea that the FAA applies in state court. But Justice Thomas dissents, saying no. That's a pretty useful practice tip, I would say, for people. I mean, what you know is that if you have a cert petition coming out of a state court involving the FAA, you are down a vote already. At least in a case involving plenary briefing and oral argument, that you're not going to have Justice Thomas's vote. And while I think one can put too much emphasis on vote counting when you think about how the Supreme Court will rule on cases, to the extent that that matters, it's pretty clear that Justice Thomas is not joining. But I will say that in both this case and in Kindred and in the DirecTV case, the state court's violation of federal law was so clear that the justices that are, I think, and this could be a misnomer, but typically considered more liberal, had little trouble ultimately concluding that violation of federal law had to be reversed. So that's I think all I want to say about Kindred. I would love for people to jump in with questions. I know it's a group that would allow for that, and definitely more interested in helping address people's thoughts and concerns and questions than just chatting. So let me pause for a moment, and then what I might do is talk a little bit about what I understand is going on in New Jersey, and offer some thoughts on how and why Kindred might help.
Okay. Well, I was just going to say, I mean, I think I would imagine the question on everybody's mind is how does this apply to the Adelise and Sanford Brown in going forward? So maybe we should just start with that.
Yeah, let me start with Adelise, which I think is, in my mind, a fairly straightforward candidate for rethinking after Kindred. I think most people on the call, I'm guessing, are familiar with Adelise, but just to say what the holding of that case was, it was a arbitration clause that referred to arbitration, used the word arbitration, but did not expressly state there was a waiver of the right to sue in court, did not essentially detail what it is that arbitration means in sufficient detail for the New Jersey Supreme Court's case. And so the specific holding is that the absence of any language in the arbitration provision that the plaintiff was waiving her statutory right to seek relief in a court renders the provision unenforceable. And they claim neutral because an arbitration provision, like any comparable contractual provision that provides for the surrendering of a constitutional or statutory right, must be sufficiently clear to a reasonable consumer. But I think another way to understand this opinion, and I don't think it's inconsistent with what the New Jersey Supreme Court itself said, is that the word arbitration is not sufficiently clear to people. And a explanation of that term is, unlike other contract terms that typically don't require specific detailed explanation of their meaning. But that word has got to be specifically explained, and absent that specific explanation, the clause is unenforceable. Well, and Alita mentioned this. We filed an amicus brief in support of the cert petition filed by the petitioner in that case, saying that the Supreme Court should review Adelise, and the Supreme Court declined to do so in that case. But what we argued was that under a case called Doctor Associates versus Casaroto, cited in a ton of cases since, and a case authored by Justice Ginsburg, that the Federal Arbitration Act, if it means nothing else, is the principle of non-discrimination. And one of the core aspects of that is actually quite simple, and it is that you cannot demand special prominence for arbitration clauses that doesn't apply to other contract provisions. And so, just to give an example, if you had a state rule that said that contracts as a whole have to be printed in 12-point type, which would be a disaster, and which is why no state does that, but let's say they did, then it would be okay to have the arbitration provision 12-point type too. But what you couldn't say is that, as the Montana Supreme Court did in Doctors Associates, that the arbitration provision is so critical to be disclosed that it should be on the front page in 1-inch type in capital letters, and without that, essentially massive special prominence, it won't be enforced. The Adelise decision is just another version of that. It's, to be sure, it's not a font size or printing requirement, but it's a requirement of explanation that doesn't exist for other contract provisions. And just to think about that, I think it's fair to say that forum contracts today are already long, really long. And lawyers, maybe some on the call, certainly lawyers like me, have some role in that, because in order to create certainty for the companies that are parties to those contracts, especially after a lot of litigation that explores the meaning of those contracts, what often happens is, to provide certainty, you explain what the contract term means. But the result is to make these contracts that are already long even longer. Well, ironically, the Adelise rule demands even more length in contracts by demanding an explanation of what arbitration means. That rule, if it were applied equally to all contract provisions, would basically mean that any term that was arguably confusing to consumers, what about a limitation on statutes of limitation? What about waivers of consequential damages? No layperson, I think, knows what consequential damages are. You have to recite the famous cases on consequential damages so people have an illustration. I think one reading of Adelise is that if that rule were neutrally applied, the answer is yes. Of course, that is not what the New Jersey Supreme Court is saying, because they're specifically targeting arbitration. And so I think there is a real question about whether Adelise survives Kindred. It seems like an attempt to find some way to undermine arbitration clauses that does not apply to other contracts. And I think I've tried to illustrate why it couldn't possibly apply to other contract terms in the way that the New Jersey Supreme Court has applied to arbitration, in part because I think it's hard to find examples of, and this goes very much to Kindred, to find examples of situations where this ostensibly neutral rule is being applied in other contract settings. And actually, in Kindred, there's a useful footnote by Justice Kagan that talks about how the rule, the clear statement rule, does not, there's both for this, or actually worth reading. Footnote 1 says that making matters worse, the clear statement rule doesn't appear to apply to other kinds of agreements that relinquish the right to go to court or obtain a jury trial. So, for example, it seems pretty undisputed that somebody who holds a power of attorney can settle a case on behalf of the resident. If a power of attorney means anything, it means that. But the consequence of that is waiving a right to trial by jury. And of course, there had never been a case in Kentucky where a settlement was vitiated on the basis of a lack of express authorization to trial by jury. And then in footnote 2, Justice Kagan goes on to say, well, it's not that you couldn't adopt a brand new rule of law that's generally applicable in an arbitration case, but it must be general, not single out arbitration. And you can see in the text, that this is quite colorful, that the fact that that the hypothetical examples raised by the Kentucky Supreme Court of other settings that would require express authorization, such as contract for a power of attorney that would waive the right to worship freely or consent to an arranged marriage or bind somebody to servitude, not only is sort of patently hostile to arbitration, but the examples were so utterly fanciful that they were essentially fake examples. And so in a very colorful turn of phrase, Justice Kagan wrote that the way in which the Kentucky Supreme Court had constructed the rule makes clear the arbitration-specific character of the rule, much as if it were made applicable to arbitration agreements and black swans. Well, isn't that, in a sense, what's going on with Adelise, with the decision by the New Jersey Supreme Court saying that, there's sort of a protest too much. Any contract term that might be confusing, they say, any comparable contractual provision that provides for the surrendering of a constitutional or statutory right must be sufficiently clear to a reasonable consumer. But I think, if you take the analysis that Justice Kagan sets forth in Kindred, you might say, well, New Jersey courts, show me another example of when you've ever applied this rule to something other than an arbitration clause. And my guess is that there are not many. It seems to me that both as a matter of looking at the case law and as a matter of looking at what's really going on here, what's really going on is a search for an excuse to decline to enforce arbitration agreements. One can leave aside as a policy matter whether that's a good thing or a bad thing, and I might talk about that very briefly. But as a legal matter, specifically targeting arbitration clauses and singling them out for suspect status is exactly what the FAA is designed to forbid. So I think the Adelise case is one that is very vulnerable to attack under Kindred in the appropriate case. I think the one thing that is a little bit tricky about it is that in practice, many arbitration clauses are more detailed than the one in Adelise, and that's not necessarily because they should have to be. I think it's because of this kind of hostility to arbitration, some businesses are extra careful and provide long explanations. Therefore, by the way, making let's say a 10-page contract, a 15-page contract, that's the trade-off that Adelise forces. It's not really creating much in the way of illumination. But if you're a business that looks at this decision, you say, okay, well, we'll make it longer, I guess. So that's what many businesses have done. But it actually then creates a situation where businesses that use shorter contracts are arguably at a disadvantage. And an easy response to say to businesses that use shorter contracts is, well, you could always, I think most people wouldn't actually say make it longer, but you could always explain this in a little more detail and then never have to get to the preemption rule. That said, I think that when you look at a decision like Adelise and then you look at the next decision that Alita mentioned, the Morgan versus Sanford Brown Institute decision, what you're seeing is, if you give an inch, the New Jersey Supreme Court may be willing to take the mile. And so there's a bit of stretching, both about a totally different issue about whether questions of the enforcement of arbitration agreements can be delegated to arbitrators, but then once again, insisting that the arbitration clause is just not sufficiently clear under Adelise. And I think what will happen is that unless you write this, long, detailed arbitration provision, if you're stuck in New Jersey State Court, you run the risk of not having the clause enforced. I also think that Kindred tells us that the Supreme Court has a real concern with the defiance of its decisions and the defiance of the Federal Arbitration Act, and is willing to peek a little bit behind the curtain and confirm whether a ostensibly neutral rule is in fact really neutral, because just because the state court says so doesn't make it true. And that's exactly what happened in Kindred. That's what happened in DirecTV. And I guess at least from my perspective, that is what should happen in the next case that raises whether Adelise is preempted. That was a pretty long answer to your question, Alita, but I hope that telegraphs at least my views of what's going on in New Jersey.
Yeah, no, that was a great answer to all of that. Do you have any? Did you have any thoughts? I don't know if you've seen any of the bills that have been introduced in the New Jersey legislature. I wonder if you had any thoughts on the feasibility of holding waivers of jury trials and limitations on discovery in an ostensibly neutral way as being consistent with the Federal Arbitration Act.
Yeah, so I think there are two things. I think that it can be difficult to make legal arguments to legislatures. As a policy matter, I don't know whether or not a legislator would care if they were enacting a law that was certain to be preempted. I think an argument that I think is legitimate to make and appropriate to make is that such a law is just going to lead to litigation that is both costly and where the outcome is predetermined. And so do you really want to essentially waste the money of citizens of your state on litigation where the outcome is predictable and essentially would destroy the legislation that was enacted? It seems like sort of the opposite of what you want the legal system to do. So that's a policy view of enacting a law that is unconstitutional. It probably is worth saying actually that phrase unconstitutional, it sounds like like a serious thing to say, but in fact it is totally what one should say about a law that violates the Federal Arbitration Act, because the reason that it's unconstitutional is because the federal statute is supreme over state law, and the vehicle for that supremacy is Article 6, Clause 2 of the Constitution, the supremacy clause that makes federal law supreme as a structural matter. And so that's why it is both fair and right to say that the proposed legislation you describe is unconstitutional. Now, why is it unconstitutional? Because a law that says it is improper to waive the right to trial by jury and it's improper to contract for limitations on discovery is really just a not that sneaky way of saying it's improper to agree to arbitrate. And I think the law by now is unbelievably clear, summary reversal territory clear, as Marmot held, that a statute that says arbitration agreements are unenforceable or certain kinds of arbitration agreements are unenforceable is preempted by federal law and therefore invalid. So we know that already. And, the words in Kindred are very, very helpful to this. The idea that, a rule that covertly accomplishes the same objectives by disfavoring contracts that, and again, Justice Kagan's words, oh, so coincidentally, you can hear the sarcasm, have the defining features of arbitration agreements. And the specific example she uses is a state law, a hypothetical state law that declares unenforceable any contract that disallows an ultimate disposition of a dispute by a jury. That law, at least as applied to arbitration agreements, is preempted by the FAA and therefore unconstitutional in that application. She described it as hypothetical, and maybe it's still hypothetical, but it sounds like if the New Jersey legislature, or at least the ones proposing that rule, have their way, then it would not be hypothetical, but it would be pretty clear. I mean, those words from the opinion make it clear already that proposed statute is preempted by federal law. I wonder if there are other things that people have on their minds in New Jersey. One thing that I think is interesting is that I suspect that if the Adelise rule is litigated in federal courts, that there is relatively little appetite for it. I think there may have been some outlier cases that are bad, but my guess is that the Third Circuit would probably hold it preempted, especially given kindred.
Hey, I was wondering if you knew if there are any cases making their way up to the Third Circuit on Adelise.
I haven't seen them yet, but if anybody sees them, I'd be real interested. I clerked on the Third Circuit many years ago. I think they try to follow federal law where they can. I think the district courts in New Jersey, a lot of wonderful federal judges in New Jersey, I think they're across the spectrum in terms of how they feel about arbitration, and that may impact in some cases how they're resolved. Very significantly, as probably many people who litigate in New Jersey know, there's a right of an immediate appeal if an arbitration agreement is denied enforcement, and then you get an automatic stay pending appeal. So if there is a legitimate basis to appeal, companies should consider it, and especially if Adelise is applied, it would be good, I think, to identify cases in which the preemption issue could be raised. One way to get U.S. Supreme Court review on these issues is to have differences between the federal circuit and the state appellate courts on the same legal question. In the DirecTV case, that's exactly what happened, was that, in fact, interpreting literally the same contract language, the Ninth Circuit had essentially dismissed as ridiculous. They used a different phrase, but the proposed interpretation that a California court later adopted that led to the Imburgia case. So DirecTV was able to point to a circuit split on its own clause. I don't think you need that level of split, but I think it would be good to be able to show if the Third Circuit had come out another way from the New Jersey Supreme Court. And then, and what's interesting is, I guess, you wouldn't if the Third Circuit got it right, a defendant wouldn't petition from that, but you would be able to point to the Third Circuit decision in petitioning from a state court case.
Right. So it would be a multi-step process.
Yeah, I mean, and one thing that's interesting is that, and this is, I think, part of what explains some of the mischief of some of the state courts, is that the U.S. Supreme Court is not, as a practical matter, going to review each and every case that comes out of state courts. It only reviews the cases that are brought to it in the first place, and it has, discretionary authority over its docket. So, I want to say earlier this week, maybe it was yesterday, the court denied review in a case coming out of Missouri involving arbitration that most people thought had been held for kindred. The facts were, I think, quite different than kindred, but the question of whether there was FAA preemption involved similar questions about discriminatory application of state law. And they had a very good lawyer, but so you never know when it comes to cert. And I think it's important, just as I think the plaintiff's bar does, and I give them credit for it, to take a long view of these issues and think, in a sense, more programmatically about litigation. One thing that I will say that I think ALITA and the New Jersey Chamber, or the New Jersey Civil Justice Institute, as well as the U.S. Chamber, because the U.S. Chamber and the New Jersey Civil Justice Institute often work hand in hand on litigation questions, like the Adelise brief, because I think ALITA and her colleagues and the folks at the Chamber do take a long and programmatic view of issues affecting business. Arbitration is a pretty critical one. So both are always worth consulting, because they may see a lot of different cases and know whether, your case is a really good one or maybe one that's not worth the one to raise, and then you might later get the benefit of a better case.
Do you have any closing thoughts on this before we wrap up our call?
I'll just say a couple of words. I encourage people with questions to reach out for sure. I certainly think this is an issue of importance. I think the U.S. Supreme Court, and kindred underscores this, is concerned about state court defiance of federal authority. I think that the right kinds of cases need to be brought to the U.S. Supreme Court so it can continue to to do, at least some form of policing here, because who else is going to watch state courts when, like in Adelise, for example, they go haywire? So, keep an eye out for good cases and report them to Alita, who I think has been doing a great job of monitoring litigation throughout New Jersey and trying to find out when the courts and legislatures are dodging federal law in ways that are unfair to businesses.